It looked like almost feral animals. It was terrible.
12 feet by 12 feet. That's the space 4 adults kept 16 children confined to for close to 4 years, while the state had no idea they existed. Third world conditions. That's how the sheriff who found them described it. The oldest of the 16 was 18. The youngest was 17 months old. And the only reason anyone found out is because one of the adults inside that house was already facing an unrelated criminal charge. This case did not start as a child welfare investigation. It started with a set of misdemeanor charges against one man, Gary Siders Jr., for indecent exposure. Authorities allege he exposed himself outside his home to people who were not part of his household on 4 separate dates in May 2026, on May 23, May 27, May 29, and May 31. That warrant, filed separately from anything involving the children, is what actually brought Vinton County deputies to the property on Omer Road in Hamden on the morning of June 30th at around 10 a.m. At that point, nothing about the situation suggested deputies were walking into anything beyond a routine warrant service.
It was unexpected. Nothing could prepare us. Even in 22 years of law enforcement, nothing could have prepared us or me to see the scene. I've never seen human beings live in that condition before, especially kids. And as we just kept getting kids out of the building, my deputies, all of us are parents. It was pretty hard experience to go through.
There was no active child welfare case attached to this address. No prior report on record had flagged the home for the conditions investigators were about to find. That gap matters, because it means the legal process that ultimately exposed this case had nothing to do with the children at all. It was a coincidence of enforcement, not the result of anyone actively looking for them. What deputies found once they were inside changed the entire scope of the investigation within minutes. According to Vinton County Sheriff Ryan Kane, investigators discovered 16 children living in the home, ranging in age from 17 months to 18 years old, most of them confined to a 12-foot by 12-foot room for roughly the last 4 years. 7 of the children were transported to Columbus area hospitals for evaluation, with at least one described as being in critical condition. Officials said conditions in parts of the house were severe enough that investigators could not fully access certain areas during the initial search. 4 adults were arrested that same day. Elizabeth Siders, 33, the children's mother; Gary Siders Jr., 36, her husband; Gary Siders Sr., 73, and Christina Siders, 66 or 67 depending on the report, Gary Jr.'s parents and the children's grandparents. All 4 were booked into the Southeastern Ohio Regional Jail, arraigned the following day, July 1, and all 4 have since pleaded not guilty to the child endangerment charges filed against them. Here's why the origin of this case matters more than it might seem on its face. If deputies had never been sent to that property over an unrelated misdemeanor complaint, there is no clear indication anyone would have known what was happening inside that house. Not that week, not that year, possibly not ever. No agency was actively investigating this family for child welfare concerns at the time deputies arrived. That single detail raises the question this case is going to have to answer eventually, not just in a courtroom, but in front of state lawmakers and child welfare officials. How does something on this scale go unnoticed for years? And what does that say about the systems whose entire purpose is supposed to be catching it before an unrelated warrant has to do the job instead? What officials described inside that home has been widely reported, and it deserves to be laid out plainly, in the officials' own terms, without turning it into a spectacle for its own sake. Attorney General Andy Wilson told reporters that what investigators encountered was, in his words, pure evil, and said the evidence uncovered since the initial search has only reinforced that assessment. He described the children as having a limited ability to communicate, comparing their condition to that of feral animals, and called the conditions inside terrible. Sheriff Kane offered his own account in a separate press conference, describing the residence as reflecting what he called third world conditions and confirming the children had been kept largely confined to that 12 by 12 room for most of the past 4 years. Investigators reported observing what appeared to be stacks of garbage throughout the house, and photos released by the Associated Press from outside the property show items including an open window with a bag of rice and a can of insect killer sitting on the sill. Kane said the department was, in his words, sickened by what they found. It's important to slow down here and separate two different things, because this is where public reaction and legal reality tend to pull apart from each other. What Wilson and Kane described publicly in press conferences is their characterization of the scene, delivered with the kind of language officials use when they want the public to understand the severity of what happened. What prosecutors will actually have to prove in court is a specific legal standard, that each defendant, individually, knowingly created a substantial risk to a child's health or safety, or failed to act when they had a duty to protect that child from that risk. Those are not automatically the same thing. A shocking scene, described in stark terms at a podium, supports public outrage and public attention. A conviction requires the state to prove each element for each child against each specific defendant beyond a reasonable doubt, using evidence that holds up under cross-examination, not just under a microphone. That distinction isn't a technicality, and it's not meant to diminish what was found. It's the entire reason a case like this moves as slowly as it has through the courts, even when the public reaction is immediate and intense. Investigators have confirmed 7 of the 16 children required hospitalization. Multiple reports indicate none of the children were enrolled in any school district, and the family had lived in at least 2 other Ohio counties over the past several years based on available records. Those 2 facts, no school enrollment and a documented pattern of relocation, are going to matter enormously to how prosecutors build their case, because they speak directly to intent and awareness over time, not simply to the conditions investigators walked into on a single morning in June. Before you continue this story, take a second to hit subscribe and share this video. Cases like this move through the courts slowly, and there's a lot more here worth understanding carefully. Now let's get into the charges themselves. All 4 defendants are now facing a combined 68 felony child endangerment charges according to filings. That number reflects multiple counts tied to each of the 16 children individually, not one single blanket charge covering the whole household. Under Ohio law, child endangerment charges typically require prosecutors to show that a person with custody or control of a child either created a substantial risk to that child's health or safety, or failed to act when they had a duty to protect that child from that risk. This is where the case starts to split into genuinely separate legal questions for each defendant, and it's worth walking through why. Elizabeth Siders is the children's mother, present in the home with direct daily custody. Gary Siders Jr. is their father, also present, also facing an entirely separate set of misdemeanor charges connected to the indecent exposure allegations that started this investigation. Gary Siders Sr. and Christina Siders are the grandparents, and their legal exposure depends heavily on what prosecutors can show about their actual role and control over the children's daily care, not just their presence in the household. All 4 have pleaded not guilty, and all 4 have since waived their preliminary hearings, sending the case directly to a grand jury under a newly appointed special prosecutor. Waiving a preliminary hearing means skipping the early court proceeding where the defense would normally get to question witnesses and see an initial look at the state's evidence. According to reporting on the decision, it aligns with comments from Elizabeth Siders' attorney, Thomas Stoley, who has described his client as focused entirely on her children rather than contesting the process at this early stage.
There's a separate developing complication specifically tied to Gary Siders Sr. After his arrest, he fell while being transported to jail and was hospitalized in Athens, Ohio, fitted with a GPS monitoring device while receiving care. Reporting indicates a more serious health issue was discovered during that hospital stay, one serious enough that providers recommended transferring him to a facility better equipped to treat it. His legal team has also raised the possibility of a competency evaluation and a potential insanity defense, according to court reporting, though neither of those has been formally resolved. If a competency question is raised and upheld, it can pause proceedings against him specifically, without affecting the case against the other 3 defendants. Before we move on, a quick thank you to everyone watching and supporting this channel. Your presence truly keeps it alive. This community keeps growing because of people who believe in real, honest storytelling. Becoming a channel member unlocks exclusive extras and behind-the-scenes content, and it directly helps us keep bringing these stories to light. We would love to know who is here. Drop a comment and tell us where you are watching from. If you are still with us right now, type "I'm still here" in the comments. Let's see who makes it to the end. And if you have not already, tap that like button. Now, let's continue. Officials have described this case publicly using a specific term, intra-family. That word signals investigators believe the relationships inside this household go beyond a standard parent and grandparent structure, and that there may be biological relationships among family members that add another layer to the investigation. Officials have not detailed the specifics, and this part of the case remains actively under investigation, so it needs to be treated as exactly that, an open question, not a settled fact. Elizabeth Sider's own history is part of what makes this case legally complicated. She and Gary Siders Jr. married in March 2008 when she was 15 and he was 18, with a judge's approval, which is legally permitted in some circumstances under Ohio law as it existed at the time. Their oldest child, now 18 and among the 16 found in the home, was born 2 months after that marriage. Some unverified reports have suggested Elizabeth Siders may have begun having children as young as 13, and that the couple may have had as many as 20 children in total, not just the 16 found. None of that has been confirmed by authorities, who have only verified 16 children were removed from the home. This history has already become relevant to how legal experts are discussing Elizabeth Siders' potential defense. A forensic nurse who spoke to News Nation, Rachel Fisher, said it's possible Elizabeth Siders was herself a victim of long-term coercion or abuse, but stressed that possibility does not automatically clear her of responsibility if the children in her care were harmed. Fisher described this as a potential victim-offender overlap, a legal and psychological concept where a person can simultaneously be someone who suffered abuse and someone legally accountable for abuse committed against others under their care. This is a genuinely difficult legal position, and it's worth being honest about why. Courts don't treat "I was also a victim" as an automatic defense to charges of endangering someone else, but they do allow it to be raised as context that can affect sentencing, or in rare cases, the charges themselves. Whether that argument gains traction here will depend entirely on what evidence Elizabeth Siders' legal team can present about her own history, and how directly prosecutors can tie her actions, not just her circumstances, to the specific harm each child suffered. That evidence hasn't been made public yet, which means this is one of the biggest open questions the case still has to answer. One detail in this case may end up mattering as much as anything found inside that house: the family's own movement. Investigators say the Siders family relocated multiple times across Ohio over roughly the past 20 years, with records showing them living in Gallia County as recently as 2022 and 2024, before ending up in Vinton County. None of the children were enrolled in any school district, according to the Vinton County local school district itself. That combination, frequent relocation and zero school enrollment, is not incidental. Schools are one of the most consistent points of contact the state has with children, and teachers are mandated reporters, legally required to flag signs of abuse or neglect. Take school out of the picture entirely, and one of the primary ways this kind of situation gets caught just doesn't exist. The same appears to be true of medical records. Reporting so far has not identified a consistent pattern of the children receiving routine health care that would have put them in front of another mandated reporter. There is also an unresolved and unconfirmed claim worth naming carefully because it could matter enormously if it turns out to be true. A man identifying himself as Elizabeth Siders' brother has posted on social media suggesting state welfare officials may have had some prior knowledge of the family's situation, A local reporter covering the case, Lauren Conlon, has been clear that this claim remains unconfirmed, and the Ohio Attorney General's office has said only that the investigation remains ongoing, declining further comment. If that claim were ever substantiated, it would shift part of this story from a family's alleged crimes to a system's alleged failure, and that is a very different legal and political conversation. Right now, it is exactly what Conlon called it, an unverified claim from an unverified source, sitting alongside a documented 20-year pattern of a family that appears to have made itself very difficult to find. All 16 children are currently in the temporary custody of Ohio's child welfare system. Officials have not said if any are still hospitalized, but they are expected to be placed into new living arrangements, whether foster families or residential care facilities in the coming weeks. Advocates working in Ohio's foster care system have been direct about how complicated this placement process is going to be. Heidi Wuscher, Fostering Hope Ohio Youth Wellness Program Director, told News Nation, "This appears to be an extraordinarily complex situation, requiring expertise across multiple disciplines, including foster care, mental health therapy, behavioral health support, and financial assistance." A man who identified himself as a distant uncle of the children said the extended family was horrified to learn what had happened, but also indicated that a family foster placement is unlikely, given the distance in that relationship. The state itself is preparing to provide direct financial support. According to Ohio's Department of Children and Youth, the state is considering investing $1 million to help cover foster care placements and court proceedings related to the case, with the state controlling board expected to consider approving that funding at its next meeting. There's a difficult precedent worth mentioning here, not to draw a direct comparison, but because it illustrates exactly what advocates are worried about. In the well-known Turpin case, another instance of extreme long-term child confinement, several of the 13 children involved were placed into a foster home where they were abused again. That outcome is precisely why advocates are emphasizing that removing children from a harmful home is only the first step, not the resolution, and why the coming placement decisions for these 16 children carry so much weight.
As of the most recent court reporting, no new hearings had been scheduled for any of the 4 defendants beyond the grand jury process now underway. A special prosecutor has been appointed to handle the case, and it will be tried in Vinton County, based out of MacArthur, Ohio. No trial date has been set, and given the scale of the charges, 68 felony counts across 4 defendants tied to 16 individual victims, this case is realistically expected to take a significant amount of time to work through the courts. All 4 defendants remain presumed innocent under the law, a fact that matters just as much now amid intense public attention as it would in any other case. Gary Sider Sr.'s medical situation may complicate his individual timeline further, depending on what his ongoing evaluation shows. Elizabeth Sider's legal team appears to be positioning her case around her own documented history, while prosecutors will have to determine how directly that history connects or doesn't connect to the specific harm each child experienced. What happens next in this case will be decided in 2 separate places that don't always move at the same speed. A courtroom where a grand jury now has to weigh whether the evidence supports moving forward on all 68 counts or some smaller number of them, and a child welfare system already stretched thin that now has to figure out how to rebuild 16 young lives. We'll be following the grand jury proceedings and bringing you the next update as soon as it happens. Subscribe now so you don't miss it. Like this video if it helped you understand the case clearly, and share it with someone who needs the real facts instead of the headlines. We'll see you in the next one.